I'm Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We are delighted that you're able to join us virtually today for this next webinar in our virtual webinar series. The Trust is pleased to be able to offer this informative content free of charge to our policyholders. Most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of the many benefits our policyholders receive through the Trust. 3 of our advocates are with us today, Drs. Eric Harris, Julie Jacobs, and Lisa Bryant. This virtual webinar will earn you 1 CE credit. This can be combined with 5 other risk management credits to save up to 15% on your Trust-sponsored professional liability insurance policy. Again, I hope everyone learns a lot over the next hour. Please join me in welcoming our esteemed presenters.
Thank you so much, Jana. And yeah, so we'll just go ahead and jump in and hope the internet stays strong for us here. So we're going to start, as we normally do, with a couple of questions that we've gotten in between the time of our last webinar and today. And then, as usual, once we make it through those, we'll dive into your live questions that you write into us as we go. So the first question, Eric, I'm going to start with you on this one. As you know, we've had many inquiries now from clinicians who want to transition their practices to a telehealth-only practice, meaning completely dropping the brick and mortar business altogether, like no office building, and they want to work from home sort of permanently. We've talked about some of this in our last webinar, but I'm wondering, can you give us sort of an update and sort of maybe even just a review of the things that folks should be considering if they're considering doing this, going to a telehealth-only practice?
Sure, Lisa, I'll do my best, although this is a very complicated question, and I'd like to say at the outset that for individual situations, you may have more complicated questions, and we would be happy to have you call and use the risk management services to discuss your individual cases. So when I was rehearsing for this last Tuesday, a couple of days ago, it turned out in the Boston Globe, there was a headline that said, "Insurers, hospitals at odds in Beacon Hill telehealth debate." And groups representing hospitals and doctors wanted strong reimbursement and essentially parity between telehealth and in-person therapy. But the insurance companies want to defray the cost of they take a different view because if you're going to do teletherapy only, the part of the formula that figured out what the reimbursement should be in the first place took into account overhead. And the idea is basically that at least in the long run, overhead for doing teletherapy would be less, and therefore it might warrant less money in reimbursement. I raise this because it's a little bit hard to give you advice about the future. To quote Yogi Berra, the future is very difficult to it's very difficult to predict things, particularly the future. Although evidently he stole that from Niels Bohr, who is some nuclear scientist somewhere. I don't know much about him. So this is only one of a number of complex issues that practitioners must consider, and it would take a lot longer than we have to discuss them all. But it reminds me of something that I learned back in the dark ages when I was educated as a therapist, which is the middle of a crisis is not the best time to make major life decisions. I think that we have no idea really about what is going to happen when the pandemic is over. And so making decisions that involve, 5, 10, 15, 20 years of your career right now, with the lack of certainty that we have about what's going to happen, is unwise if you don't have to make that decision. But I realize that some people feel that their business has fallen off and their overhead costs have gotten to the point where if they can practice entirely telepsych from home, they would have a lot of less expenses than they normally would have. So there are 3 basic areas of complexity I think it is important to consider. The first is clinical. And I think that's the most important one. How confident are you that you'll be comfortable both personally and professionally doing nothing but Zoom sessions in both the short and longer terms? Do you personally feel that this is the best way to meet your clients' needs? Or do you feel that the ability to do a combination of remote and in-person sessions or in-person only would be the most effective and satisfying way to run your practice? Is telephone something that you feel more comfortable with, as the many more senior therapists have been telling me, but it's not likely that telephone therapy only will be reimbursed, or at least the situation post-COVID was that they wouldn't be reimbursed, and that the telephone services are now being reimbursed during the emergency, but not necessarily will be afterwards. The data indicates that there isn't any difference between teletherapy and in-person therapy. But we don't know what kind of technology the data that is collected was gathered on. Zoom is not high-def 3D teletherapy. That probably will become more available in the future, but not right now. So the question of how you feel about this versus how much money you think you can save is really, I think, the most significant question that you have to address. But you also have to take your clients into consideration. How are they doing with exclusive teletherapy so far? How do you think they would respond to this option when the pandemic is over? How many clients might you lose, and how many potential new clients would prefer to have options available? Preliminary anecdotal information is that most clients appreciate the convenience and flexibility of teletherapy, but might want the option to have in-person sessions at least from time to time. How well is your home set up? Can you really set up a portion of your home that will meet professional requirements for confidentiality and appropriate separation from your personal life? If you have children, how have you been doing so far with that? Having to share your responsibilities to do childcare and your professional responsibilities. You'll still have to meet HIPAA requirements, and my guess is that there will be more HIPAA requirements because of what we will learn about from all of this teletherapy during the pandemic. How close are you to retirement? And how comfortable are you with the technology that will advance rapidly? Will you be able to keep up, and will you feel comfortable keeping up? There is something to be said, it seems to me, for being able to do work that you've been familiar with and become quite good at over time. I think it's pretty clear, at least to a lot of people, that doing teletherapy is different than doing in-person therapy, at least in the experience of the person who is the provider. Then there's business issues. That's the second category. How much is your overhead? Would you be able to maintain your client base with an exclusive telehealth practice? Will you have to label yourself on referral services telehealth only, and will that create a competitive disadvantage with your colleagues who can say both telehealth and in-person therapy? I think that there's a good chance that telehealth only people will not be as competitive as people that can do both. Do you depend on insurance reimbursement? What would it do to your bottom line if reimbursement for telehealth is reduced by 20%, if it's reduced by 40%? Do your clients seek reimbursement from their insurance company for out-of-network care? Would they be willing to pay more, or would you have to give them a discount? Would you violate legal or insurance regulations? Right now, it wouldn't if you have self-pay, but it might in the future. What if insurers require a number of in-person sessions prior to allowing telehealth to be reimbursed? What are you going to do then? You're not going to be able to meet those requirements, and that's going to declare a whole possible group of patients off limits for you. Do you have a lease now? Can you get out of the lease? If you get out of the lease, do you abandon the colleagues who you share office space with and leave them to have to deal with all the expenses? How are you going to feel about that in the long run? How are they going to feel about that? How much work would it be to transfer your address for insurance and board of registration. And how much, if you have to give your home address, how much is that going to expose you to in the way of some people feeling that that puts their practice in danger or their family potentially in danger? Of course, if you Google yourself, you may find that people can already pretty easily find out what your home address is, so that may not be an issue for you. Then there's the legal and contractual issues. What's your state's position on telehealth and reimbursement parity before the crisis? Because many of the states are basically saying that all of the telehealth permissive rules that they're having, both in terms of interjurisdictional and even telehealth within their own state, are temporary as a result of the emergency. Certainly the ability to do phone therapy is something that nobody would reimburse before the pandemic. Whether they will return to that afterwards is not at all clear. In Massachusetts, where I am, there was already telehealth parity established before the COVID pandemic hit, and that will be what the situation will almost certainly be afterwards. But in a lot of states, that isn't the case, and it's not clear what the long-term result will be. Also, there are many states, or at least some states, and I don't keep track of the number of them, that require you to have an in-person, that required you to have an in-person visit or 2 in-person visits before you could actually switch to teletherapy. So you have to be careful before you make any decisions that are really difficult, that will be difficult to overcome or overturn should things get different. So that's just some of the issues that we have. We also, I want to tell you that we have a FAQ about this on our website at trustinsurance.com, and we encourage you to look at it. And for individual, again, I'd like to say, for individual situations that you want to have a discussion with folks that have thought about this, please feel free to call and schedule an appointment with one of our risk management consultants. That's it, Liesl.
Great, thanks. Anything, Julie, that you want to add there?
I just want to underscore, I think one of the things that Eric talked about that seems to be something that is the source of a lot of the potential concerns is just the inability to be flexible. So if you are thinking about moving to a telehealth only practice, maybe try to think of a way to have some bit of flexibility, to have maybe a colleague that you're able to use in office on occasion, or some ability to occasionally do those in-person services, even if it's not going to be your main focus. Having that flexibility can maybe help deal with some of these things that would be problematic in terms of cutting it off completely and going telehealth only.
And one more thing, Liesl, if I could add one more thing. There have been a lot of you out there, or a lot of your colleagues out there, who've had home offices where they've done their work for a long time. And so it is possible. The other thing to think about is, can you really convert space in your home into an actual office, which has all of the needs to where you can actually meet people professionally in person. And you don't have to do it all that often, but that would give you that kind of flexibility that Julie was just talking about.
Yeah, so there's, I mean, as you both are saying, right, there's a tremendous number of things to contemplate. And it's both a clinical issue, there are clinical questions and concerns, it's also business issues, you know. And I know, Eric, we've been getting a lot of those questions about the PO box thing. Can I use that with insurance companies? Can I use it with the licensing board? And I know we don't have time to go into all that. We'll see if any questions comes up, but it's actually a little more complex than I think we would think it is, right? There's some prohibitions there and restrictions. So it's just important to really think about all these things before you make a final decision. All right, Julie, I'm gonna direct the second question to you. And it says, I am now more comfortable with providing telehealth services and want to expand my practice to other states. If I switch to coaching, can I practice across jurisdiction without concern?
No. And let's talk about why. You know, certainly a lot of people are thinking about doing this. We've gotten lots of calls about folks who want to expand, who are a little frustrated by the restrictions imposed by the interjurisdictional practice. And they're thinking that, you know, relabeling themselves as coaches might be a way to get around this. A lot of states don't regulate coaches. It is a largely unregulated profession. But the issue is, as a psychologist, many states have very expansive definitions of what the practice of psychology is. And arguably, well, almost, I'm not even sure it's arguable. I think pretty clearly a lot of coaching would fall clearly under the practice of psychology. And so what you need to make sure of, if you're going to do coaching for the purposes of getting around the interjurisdictional issues, you need to make very, very sure that what you're doing is coaching and not psychotherapy. And that is not an easy thing to do. The regulatory boards are going to presume that what you're doing is the practice of psychology or is providing psychotherapy services. And they're conservative by nature. Their charge is to protect their consumers. So they're not going to appreciate someone coming into their state saying, I'm just doing coaching, when in fact they are a psychologist. And so what they're going to do is they're going to look at not the label. They don't care if you call yourself a coach. They're going to look at the substance of what you're doing. They're going to apply the duck test, right? Does it look like a duck, walk like a duck, quack like a duck? If it does, it's a duck. I don't care if you're calling it a goose, it is still a duck. And so you will have the potential issue of practicing illegally into that state, being considered to be practicing psychology into a state where you're not licensed. Now, sometimes that's okay, right? There are temporary practice provisions that you can practice under to do a session or two in a lot of states, but that does not contemplate a long-term coaching relationship of any kind. That is for 1 or 2 sessions on a temporary basis. So the other thing to think about in terms of the coaching question is, a lot of states will consider the service to be occurring where the client is located. So if you're not licensed in that location, then that can present that interjurisdictional issue. Some states are very explicit that no matter what, if you are licensed in another state, the service you're providing into their state is practicing psychology. I think California is one state that's made that really clear. Colorado has said coaching isn't regulated unless you have a mental health license, in which case you're going to be falling under the Mental Health Practice Act. So what you want to do is be very cautious about sort of the nature of the service you're providing. And you want to think about, what is the reasonable perception of the client? How are you marketing this? Are you making sure that you're very clear that you are providing coaching services and defining what those are, differentiating those from psychotherapy services? Think about the subject matter of the work that you're doing. Is it similar to subject matter you'd be dealing with in psychotherapy? Or is it more executive coaching or life coaching where you're focusing on things that aren't really vulnerability or mental health issues, but are more improving good functioning already? What kind of techniques are you using? Are they psychologically robust techniques? Are you using EMDR? That's going to cut against the argument that what you're doing is coaching and not therapy. And client vulnerability. Client selection is really important. How vulnerable are these clients? What's the power differential here between you as the professional and the client? In a coaching relationship, it's really ideally it's an equal relationship. It's an equal partnership. There isn't really that power differential that we see with a psychotherapy relationship. So you have to think about what are the client populations that you're looking at? What are the client vulnerabilities? The more similar the subject matter is to psychotherapy subject matter and the techniques are to psychotherapy techniques, and if there is that client or that power differential, it's a duck, right? You're doing psychotherapy no matter what you call it. So if you're going to do this kind of work, then you want to be sure that you have very clear paperwork, clear disclaimers that outline what you're doing. We actually do have a sample coaching contract on the Trust website that I think does a really nice job of defining what psychotherapy is and what coaching is and what they each are not. And it even speaks to that power differential and the fact that this is not something that we do with vulnerable individuals. So good paperwork, good case selection is absolutely key. Good client selection. This is complaint driven, right? So if you're selecting clients who are likely to complain against you, who are vulnerable and feeling harmed, then your risk is going to increase. Whereas if you're working with, high level executives who are functioning well and trying to move on to the next level, they may not be as sensitive and feel as harmed and may not be as likely to file a complaint. Competence. You want to make sure that you are actually competent as a coach. I mean, certainly a lot of coaching techniques are very similar to some psychotherapy techniques, but it would probably behoove you to get some sort of training or education or even certification as a coach and be sure that you're following those standards of practice that apply to coaching. Document your rationale for doing the services you're doing and how you differentiate this, how you see this as coaching versus psychotherapy. And anytime you're expanding your practice, especially if you're thinking about going into other states or other jurisdictions, talk to a tax professional, talk about what tax implications you might want to consider. That's always a good idea with any expansion of practice. So that's sort of a real quick and dirty. We actually have talked about this topic in several of our workshops as well. So if you want a deeper dive into this, you can look at some of our older sequence workshops and they'll give you the agenda and you'll get to see if this is one of the things that we talked about. So there's a lot of information out there. There's a lot of interest in doing this. It's doable. but you do want to manage the risk, and you want to make sure that you're targeting the right clientele, and that you're marketing yourself in an appropriate way. And Eric is sort of the pro on this, so I'm sure he may have a couple of other things. He's written a fantastic article, by the way, on our website that discusses coaching, so take a look at that as well.
Do you want to jump in, Eric?
Just one thing I'd say, I mean, again, all of these subjects are so complicated, so if you have individual issues. And the other thing I would say is that if you're going to do coaching, you need to have really good documentation. You need to do consults. You need to do the same kinds of risk management with coaching, because it is the practice of psychology that you would do with psychotherapy. They're different. Lots of times people get confused and they think the practice of psychology is the practice of psychotherapy, but psychology, of course, is much broader. The other thing I would think is, if you're going to try to claim that what you're doing is not the practice of psychology, then there is some question about whether your insurance policy would cover you. Because if you look at the trust insurance policy, we cover people for the practice of psychology. We don't cover people who say, I'm not practicing psychology, and that's the basis that I'm using to essentially do things that I couldn't do if I was practicing psychology.
Yeah, I think one of the sort of misconceptions that I know I hear a lot is people think, well, I can get around the interjurisdictional laws if I call it coaching. And that, I think, is what I hear both of you saying. No, that's actually not true. Yes, you can do coaching as a psychologist. We can all do it. There's ways to make that work, but that doesn't necessarily get you around the interjurisdictional issues. Is that right?
Yes.
Yeah. So, okay. All right, so to keep us moving here in time, we'll move on to question number 3, which is, I am in a state with very high and increasing rates of COVID infections. If I continue to see clients in person, am I liable if someone gets sick? And Eric, I'll let you jump in there to start with.
Okay. The short answer to that is, if you're making a reasonable effort to follow appropriate guidelines of the CDC and your state, and you are using good informed consent to let people know both what your responsibility, what you're going to do to keep them safe, and what you expect of them in order to keep you and other clients in your practice safe, then the chance of your being sued are very, very small. The people who would want to sue you would have to prove 2 things. They would have to prove that you were negligent, and if you are being very clear that you're following the guidelines about what is expected of people who are, you are probably considered to be an essential worker. And therefore, there are probably clear guidelines for what you need to do in that situation. And as long as you're following those guidelines, it would be hard to prove that you were negligent. But I think even more important is that they would have to prove that you are the proximate cause of their getting COVID. And that would be very, very difficult. Because that would mean that the only thing that they would have to prove, really, that the only place where they could have gotten COVID was in your office. Now, as you probably heard on the news, a lot of universities are requiring students to sign waivers, liability waivers. And we've been asked several times in calls, would we recommend liability waivers? And we don't think that they're a good idea for a couple of reasons. One is, I'm not sure that they will actually work for psychotherapy. And the real risk in psychotherapy, in our judgment, is licensing board complaints. And they will not protect you against a licensing board complaint. And this is anecdotal, but my sense of it is that licensing boards don't like arrangements that you make with your clients that starts out essentially being adversarial, which is what you're doing when you're getting a waiver like that. We do have an informed consent, and we have everything on our website, including an informed consent for returning to work. And we have a couple of fact sheets about what you need to do in order to do that. And I strongly recommend that you take a look at that. But we do, and in those documents, what we do is encourage really strong informed consent about the fact that if they come to see you in person, you're going to do everything you can to make sure that they're safe. But nobody can guarantee safety in this particular situation. And of course, again, just so you'll be able to answer the CE question that we asked, you should employ good risk management techniques. You should consult about this frequently. You should use informed consent. You should definitely take care of yourself. And you should carefully document that you have done particularly the informed consent.
Yeah. Julie, any additions?
The only thing I'll add is just to sort of echo the idea of making sure you know what your state is requiring. Some states have put out clear guidance for mental health practitioners who are trying to return to in-state or in-person services. Colorado has done that. And so it's slightly different than the typical business, the critical business is opening. So take a look at either your state board website or the state public health department's executive orders. They may have orders specific to mental health practices. And as long as you're doing that as a floor, I think like Eric said, it's going to be hard. You're not being negligent. It's going to be hard for them to prove that your actions in any way caused their illness if you've done everything that you can and followed those standards and requirements.
Can I just say one more thing, Liesl? A lot of times when lawyers do risk management, they take a very, very, very low probability event and make it seem like something that you have to protect yourself against, when in fact it fits it. You know, you're 100 times more likely to die on your way home from work in the car. And this is one of those things that I think there probably will be a number of suits. They will be institutional suits. They'll be against institutions. They will be against nursing homes. They will be against mental health clinics sometimes. But if you're in private practice, if you work in an institution, you follow the institution's policies. And then the institution will be the one that gets sued, not you. And if you're in private practice, not many lawyers are going to be willing to take cases where the odds of their being successful are so low.
Mm-hmm. And as you both have said, right, the closer in line you are with what's being recommended, maybe the safer you are as well. Just, I know we've had some question on where these resources are, because I know both of you have mentioned various resources. If you go to our website, the trustinsurance.com site, just under that scrolling picture is a little rectangular box that says COVID resources. If you click on that box, it will take you to the COVID page. And I believe almost all of the resources we've talked about are there. Informed consents, the FAQs, all of that information is going to be right there on that page. So it's very easy to find.
But also, the coaching contracts are also there. If you don't find it in the COVID page, look under resources.
Right, exactly. Look under resources and then document library for the coaching contract. And the other thing I just want to mention in terms of resources related to what Julie was saying is you can also always be in touch with your state psychological association, which may be able to give you information on what's required in your state and those kinds of things. So if you're having trouble finding information like that, sometimes they're a great source of information. Okay, last question before we move to the live questions, which are coming in. So this one says, I now have my e-passport through SIPACT, and I'm excited to open my practice to all SIPACT states. How do I advertise this and explain to potential clients that I'm practicing under the laws of the one state that I am licensed in? Julie, you want to start on that one?
Yes, it's a great question, and it may just raise more questions than answers at this point. SIPACT is brand spanking new, and so there are some things that just simply have not been determined yet. One of which is the correct, best way to market into these other SIPACT states. SIPACT, the commission is writing rules to clarify how you can identify yourself as a SIPACT provider and how to market yourself in an appropriate way, but those are not developed yet. And so until then, we fall back to the APA guidance and any state guidelines about marketing, right? You need to be very upfront and honest and transparent about marketing. You need to be clear on where you are licensed. And then in terms of how to identify yourself as a SIPACT provider, formal guidance on that will come. Until then, I would just make sure that you're being honest and forthcoming about what you're saying. Don't try to act as if you're fully licensed in those other states, because you're not. You're working under a credential that allows you to practice on a limited basis into those states. You know, one of the things that's tricky is in order for us to explain to our clients what's going on and what rules we're operating under, we have to know what they are. And so I'm just going to give a little bit of information about SIPACT as the legislation is written. And again, the legislation is in place, but the rules have not been written yet. So the legislation is sort of higher level, broader concepts, and the rules on how to actually implement them, some of those are still being written. But one thing that we need to understand is that, you know, there is a home state. Your home state is where you are actually licensed. and it's where you are sitting at the time that you provide services under ePassport. There is actually a requirement that you are physically located in your home state when you're providing these services, okay? Unlike the question that I just answered about coaching, SIPACT, the compact actually specifically says that the provision of psychological services is taking place in the physical location of the psychologist, not of the client. So there we just flipping there over on its head the common knowledge that we've had in the way we've been talking about these interjurisdictional issues. But under the compact, you are operating in your home state, and under the compact, you are to operate under the laws of your home state. Your home state is still the state that would take the lead on any investigations and would issue any sanctions against you. Even if an issue happens in a receiving state where the client is located, they're going to refer that back to your home state to take the lead on that. The one exception to the fact that you're operating under your home state rules is you have to operate under the scope of practice rules of the receiving state. So if you are in a state that has broader scope of practice than the state where your client is located, you have to operate under the client's state's scope of practice. So you need to know what that law is. I think the obvious example is for prescribing psychologists. You know, if your state has prescription privileges and you are credentialed to do that, but the state where the client is located does not, you cannot prescribe into that state. You need to follow that scope of practice law. A really tricky piece about this, and one that we don't really know the full answer to yet, are the issues of mandated reporting and duties to warn. Again, you always need to follow those laws that are in your state. So you need to be aware of what those mandates are in your state. But you also need to do some research, and you need to understand what the laws are in the receiving states. Your SIPACT is working on this now. They are literally promulgating these rules, and they're going to clarify how to deal with these specific situations. And their website is sipact.org, and they have the rulemaking is on there. They're posting new rules, they're posting draft rules. So I would suggest, if you're going to be operating under your ePassport now, you know, in the near future, keep going on, go to that website, check what those guidelines are, check what the rules are, and see if they've issued anything to clarify either of those questions. I mean, right now, because so much is up in the air, the best risk management advice we can give you is to know the regulations in your states, know the regulations in the state where you're practicing, and consult when it comes to any kind of difficult issue. If there's a conflict, if there's something you're not clear on, certainly consult with us. If you have other resources to consult with, perhaps your state association may have some guidance, or also your state board. But right now, there are as many questions as answers on some of these issues. And so this will be a learning curve for everyone as they try to implement these rules and move forward. Would love to hear if y'all have any additional thoughts on that. It's a tricky one, and it's a brand new shiny toy for us all to learn how to use.
Yeah, you did a great job there, Julie. I think it is new, and you know, there's a lot of unknowns. Eric, anything you want to add there?
I would just say, one of the things people may say, well, why isn't this all settled and resolved by now? The problem is that this vehicle of a compact is a kind of new idea for psychology, for healthcare providers, and it involves a lot of very complicated questions because it involves a lot of state governments who have all ceded their power to regulate, but it's not absolutely clear how much power they've ceded. And so some people say, well, why didn't ASPPB figure this out before? Well, they aren't SIPAC. They're the people that helped facilitate SIPACs being able to be in an operation, but SIPAC is now an independent quasi-governmental agency, and it's just going to take some time for it to work all this out. But nobody has been, in my judgment anyway, nobody has been negligent, or this is a very new and very complicated thing that they're doing.
Yeah, and as always, right, when we're doing something new and potentially complicated with unknowns, we want to, of course, be aware of what is unknown, and we want to be cautious as we go into it, right? So really educate yourself, for those of you who are practicing under this, and stay as abreast of the information as you can. Okay, so we have a bunch of questions. I'm going to try to dive in so we can get to some of them real quick. Let me just quickly say, I know a couple people were asking Eric about your initial question, and just to let you guys know, he spoke about 1, clinical issues, 2, business issues, and the third was legal and contractual issues related to that question of whether or not, you know, what to consider with the home office. So those were the 3 categories. One question we have here is, I am being asked to testify as a custody evaluator via Zoom in October. Are we permitted to testify via Zoom? And are there any ethical implications I should consider? Or should I decline to testify in this manner? And Julie, do you want to jump in with that to start?
Sure. Yeah, I mean, I think it's actually not unusual. There's a lot of courts in a lot of different states that have waived some of the rules about testimony, and you know, remote testimony isn't something that's unheard of, but these days it's certainly much more common. There are a lot of things to consider before you testify without even thinking about the remote aspect of it. I mean, you certainly need to make sure that you have proper authorization from the people whose information you're going to be disclosing, or short of that, you have court order that would compel you to disclose information. We always want to discuss risks of releasing information or involving mental health records in litigation. So if you haven't already had a conversation with the client about whom this is related to, talk to them about the risks. You know, the fact that you can't control how information in the record or information that you share is interpreted or used. It could somehow harm the case. It could, you know, you stay within your scope. So if you are a custody evaluator and you've done a custody evaluation and they have proper informed consent, then you are able to make recommendations about custody. Outside of that role, if you're a treating therapist, and I know this may not be the exact question, but if you're not in a role of an evaluator, don't make statements that an evaluator would make, right? So stick within your scope and within your role and within the things that you can speak to and support with the evaluation of the work that you've done. In terms of, you know, I don't know that there's anything specific to using Zoom. You know, it's not unusual, and I think what we're finding is court looks like this these days, right? There's just a bunch of different screens, and folks are trying to do what they can to stay safe. So I'm not sure that there's anything real specific to the remote aspect of it. Eric, if you have any thoughts on that, certainly jump in. But I really just think about the testimony pieces as, you know, sticking to the facts, the things that you've observed directly, things that you've evaluated for or that have been reported to you. Offer opinions only if you've actually evaluated and have a basis upon which to state those opinions, and make sure that you either have a court order or appropriate informed consent from the folks about whom you're talking. So we'll toss it over to Eric if you have any thoughts.
Well, I only have the thought about it. It's no different than anything else. You had to, when you switch from something that you're familiar with and very competent to do to something that's unfamiliar and that you don't feel confident doing because of the technology involved, it's always a good idea to do a little practice beforehand to make sure that you are able to use Zoom as well as if you were giving testimony in person. I don't think there's any legal difference between testifying remotely or testifying in person. In fact, before COVID occurred, there were lots of times in which people were asked to testify remotely because of distance requirements or availability issues. So I don't think there's any real difference. But I think it's like when you switch to psychotherapy by Zoom, you lose something because you're not familiar with the process. And it feels more risky because of that.
Okay, great. Thank you. So we have another question here, and this gets back to the issue of the home office. If we switch to that, it says, can you come back to the question of using a PO box as an address? I've used one for years in Massachusetts, even with an address. What are the issues or limitations? Do you want to jump in there, Eric?
Yeah, it's a state-by-state thing, and it's an insurance company by insurance company. Licensing boards sometimes require licensing board addresses that you use for a licensing board is a public record. And we're not sure that I know that Massachusetts will allow you to use a PO box, but some states may not. Some states may require you to actually have an address in person. We also don't know whether or not what the situation with Medicare is going to be after this is over for teletherapy, because there was no teletherapy before. And so we don't know about that. But it's a state-by-state thing in terms of a post office box.
Yeah, and I think some of and Julie, you can speak to this too, but some of the issues also have to do with, you know, if you're using it as an address for your physical business, that's actually disallowed by some of the PO box regulations. But if you're using it as a mailing address, that may be different. So there's some complexity. You want to comment on that?
Yeah. I mean, a lot of post offices actually offer the option of a street address service. So you would use the post office's street address and then unit 1234 if that was your PO box 1234. However, and that would potentially be a way around it if you need to have a physical address that a PO box is not good enough. But if you read the user agreement for post office boxes, it specifically prohibits you from using the street address service as a business address. So that makes it a no-go for that particular thing. Now, UPS stores, mailboxes, et cetera, stores, there are still some other stores that offer a similar service. You can get a PO box and a street address. They may not have similar restrictions in their user agreement. Another option is virtual offices, right? There's offices that you can just rent, you pay a monthly fee, you use their address. They can either hold mail for you or they can forward it to you, but you are legally able to use that address as an address of record. So there are some ways around it, but the PO box thing, I think, like Eric said, is very specific to the states. I actually checked with Colorado. You are allowed to use a PO box as your business address on your mandatory disclosure statement and informed consent, but the board will still want a physical address that they actually will keep confidential. And so it just really depends. You'll need to call and ask the board and ask them what information is going to actually be published and would be public record versus what could be protected. And then similarly with the insurance companies, some may accept a PO box as an address, some may not. And it's a lot of work and it's a hassle, but you kind of have to call and ask and make sure that there's no prohibition or no issue with that.
Mm-hmm. Great, thanks. So we're getting a bunch of telehealth and cross-jurisdictional questions, which, keep coming up over and over. So the first one here is, could I continue seeing a college student through telehealth with residents in our state where we have a long-standing relationship while she is away at college in a different state? In other words, does residency matter? Eric, you want to start there?
I would just say that we aren't going to be able to answer these questions because they're complicated. Call the service, really, because it depends on the characteristics of the clients, what the problem of the clients is, what state you're working into, what your level of risk tolerance is. Most likely there is a way that you can do that, but in order to do it effectively, if you want a really effective answer, I really think that is something that you ought to call and talk to a risk management consultant.
I will jump in and say that, pre-COVID, I think we might have been more conservative in that response. If someone's going away to college, they're going to be away for 9 months. It's probably reasonable for them to connect with a provider who's where they are. In the days of COVID, as we know, someone can go away to college and then college shuts down 2 days later and they may be coming back. And so with so much uncertainty, yes, there is still risk. There's also still concerns about clinical and ethical considerations and continuity of care and making sure that people aren't getting jerked left and right. So like Eric said, this is a question that we field all the time, but with the specifics in a phone call, it's really hard to give guidance without knowing more about the nature of the relationship. I will say, I think one of the things that was in that question was, does the residence matter? I don't know of anywhere that your state of legal residence actually matters. I think it's really going to be either the pre-SciTac thinking was the service is happening where the client is located. If you're working under an e-passport, the service is happening where you're located. It's going to be a pretty fact-specific kind of analysis to engage in. But legal residence, that's, I think, pretty irrelevant. I think it's really more where the physical locations are for the therapist and for the client.
And I'll just say one more thing. There is a dispute about some of these areas. About what the law actually says, what the authority of a state to assert jurisdiction over you if you're working with a client where you're just extending services. And that's why I'm saying call specifically, because the facts and circumstances of the particular situation are very important in giving advice about whether you can or can't do it.
Right. I think what you're both saying, right, is that there's no one right answer here, right? It's specific, and there's multiple factors. There's the interjurisdictional legal factors, there's the clinical appropriateness and clinical risk factors, there's maybe temporary licensure or COVID waiver issues to think about, there's how long will it be. There's so many issues. So I agree with both of you that on this one, we can give you those general pieces, but really you want to call in about any specific thing. And the other thing I'll say, and Eric and Julie, tell me if you agree with this, but that, it may be that it makes sense to do it in one case and not another, because it really is.
Absolutely.
No, absolutely. Yeah, no, that's exactly why I'm saying that this is not something that one size fits all. So we can't really answer it in general.
Right.
What we can say is it's not absolutely prohibited depending on the facts and circumstances.
Right. Right. Here's one that I think is easy to answer. If I'm licensed in 2 states, can I provide psychotherapy remotely in both? Julie, you want to jump in there?
I think yes. When you're licensed, you can provide therapy, and if you're lucky enough to be licensed in multiple states, you eliminate the interjurisdictional issue because you're practicing within jurisdictions in which you are licensed, and the boards in those states can sanction you if you do bad things. That's really the overarching concern. The board wants to be able to smack you if you are harming their residents, and if you're licensed in that state, they can smack you. They can put sanctions on you or revoke your license if they need to. So.
Another way of defining smacking you would be to say that they want to be able to protect their consumers, and the way they do that is by having you be licensed, because then they have absolute jurisdiction over you. And the whole issue of interjurisdictional practice is about how state licensing boards can protect their consumers and what makes sense in terms of regulating a new technology that takes place in cyberspace, which is not regulable, and it needs an earthly site. Massachusetts used to have a rule that said you had to be licensed both where the client was and where you are. And what I basically said is that's the first quantum theory of jurisdiction I've ever heard of, because you had to be in 2 places at once. And that legally is not a legitimate position. You have to choose one or the other, which is why the state licensing boards say you're practicing where the individual is licensed. But interestingly, SIPAC, because of the ease of regulation, has turned that, as Julie said previously, on their head, and because you have to follow the rules in your state.
Mm-hmm. Right. Okay, here's another one from an employer perspective. She says, my employees are all teleworking. If they are injured while teleworking, is workers' compensation or their homeowners insurance more likely to cover? Next question. I am wondering about my responsibility for the safety of their home office setup, so forth and so on.
Let me just say that that's a question you have to talk to a local attorney about. The employee workers' comp, things like that, vary so much from state to state that it would be our giving you legal advice, not risk management advice. The risk management advice is you need to consult with local counsel about that. And again, your state association may have some information to help you to figure out who a good lawyer is, or they may even have some information about that. But we can't, that's not advice that we can give.
Great. Okay, here's another one. Is it legal or ethical to decline providing treatment or assessment as a general practice policy if during the informed consent process, prior to establishing a professional relationship, the potential client indicates they will not give permission to share the assessment results or relevant treatment information with a referring healthcare provider, if the practice additionally only accepts referrals from the healthcare provider? That's a little bit complex. Maybe you can speak to it just generally in terms of, can a practitioner sort of have a general practice about whether they will or won't provide treatment assessments under certain conditions?
Yeah, I mean, I think you are able to set limits as long as you're applying them objectively and fairly. You can't you can't have policies that are discriminatory against a certain class of people or a certain type of people. But if you have a policy that when I have a referral from a certain source, I'm going to provide information back to that source, and you explain that to a client up front and they say no, you are allowed to say no to people. You are allowed to set boundaries on the work that you do and set parameters and policies on the work that you do. Again, as long as it's not done in a way that would be deemed discriminatory or problematic. If it's just a standard policy, you'd want to think about the reasons behind that and think about, from a business perspective, does that make sense? And is that going to be off-putting to people? But I don't see any specific prohibition or issue with that piece of the question.
However, let me just say that people can change their mind. And so you may have that policy and they may agree to it and then later say, no, they see the results and they say, I don't want that information going. And in that situation, I think you have to respect their right as clients not to turn the information over unless it's like a school system and they're paying for the evaluation. in which case you can say, well, if you aren't going to let me turn information over, you need to reimburse me for my time. And that all has to be in your informed consent. But one of the things I would recommend is if you've got regular referral sources, they will know about HIPAA and things like that. And all you need to do is say, well, I'm going to have this in my policy, but of course, if the client changes their mind and says that I can't turn it over to you, I'm going to tell you that I don't have permission to release the information. And hopefully they're going to understand.
Mm-hmm. Yeah, that's a really good point. Related, also on the topic of informed consent, another question, if a patient signs the informed consent, does that mean I have documented informed consent, or do I need to document that in a progress note as well? Julie, you want to, or Eric, either one can jump in.
Yeah, I mean, I think the signature is pretty good evidence that they signed the form. I don't think there's any harm, and I think there is some benefit in having a real quick note in your progress note that just says reviewed informed consent with client, because you always want to give them the opportunity to ask questions and answer them. And just, handing a form to someone, or I guess these days we don't hand forms to people. Having someone fill out a form online and email it to you doesn't mean they read it, and it doesn't mean they understand it. That is not truly informed consent. You really do need to have a conversation, and it could be as brief as, do you have any questions about what you read? Do you understand the limits of confidentiality? I think there are some things that you might want to actually highlight, and then a super quick note. I don't think you need to go through exactly every specific question they might have had unless it seems clinically relevant or notable, but to just indicate that reviewed informed consent with the client, I think that's a good idea.
Mm-hmm. Yeah, I agree. So it becomes more process. Eric, any addition there?
Nope.
All right. Next question. I work for a college and students need to self-report their positive COVID-19 status to the college. If a client self-reports this to me as a licensed psychologist in session, am I able to share this to the college? Eric, you want to jump in?
Well, it's interesting. I just had that call today from somebody that works at a college. And I would argue that depends. If you are required to, there are many colleges that require you to release information that indicates danger to the college community. And if that is what the informed consent is, and that's what your agreement is with the university that you work for, then you would be able to release that information. And that's where informed consent becomes very important. The call that I got today is that the university evidently was making a decision that they couldn't change their informed consent, which I said, well, that's a very difficult situation, because you're sort of caught between the university's, your job requirements and what you think is ethical. And that's a very difficult question, which I don't have an easy answer for. But with college campuses, many of them do have the provision that says, if you present a danger to yourself or others or to the college community, that's what we recommend for colleges. In that case, having them knowing that they have COVID, or if they, have other diseases which would be infectious to the college community, you're allowed to breach confidentiality, but that has to be in the informed consent.
Yep. And if it's not something that's already in your forms, because we didn't all create forms for COVID, then at least do it verbally, explain that verbally, and document that you explain that to the client. But ideally you could have, if you look at our sample informed consent for returning to in-person services, it does talk about the fact, and I know this isn't exactly the question, but it does talk about the fact that, we may have to report to a public health department if we find out that you or one of our clients is tested positive. So having something similar to that and letting clients know that, if they're required to self-report something and they're telling it to you, then you may have to do that as well. You may consider that a risk to the campus and to the community and have to breach confidentiality.
Great. Okay. I'm going to try to squeeze in at least two, if at all possible. I know we're on time, so we'll see how that goes. Here's one that hopefully will be a little bit fast, and a clarification. It says, just to clarify, I have a Pennsylvania license and live in New Jersey. I plan to apply to SIPACT. I must be physically sitting in Pennsylvania in order to work under the SIPACT certification. Is that correct?
Yes, but right now, there may be state laws that in your state that allow you to practice across state lines. I'm curious, Julia, whether you think that would that is sufficient to satisfy the SIPAC requirement that you're practicing under the laws of the state that you're in, if they have an exception to where you're located.
I think that SIPAC is fairly clear, and I think this was so surprising to people, that you declare a home state where you're licensed and you have to be physically sitting in that state. So if you're licensed in 2 states, and even if they're both SIPAC states, well, let's say one is and one isn't, which I think might be the situation here, you have to be in the SIPAC state in order to practice under SIPAC, even if you are licensed in New Jersey. Now, while you're in New Jersey, you could potentially practice under some other temporary practice provisions, but you would not, as far as I understand it, be able to practice under SIPAC. You have to have your physical body is in your home state while you're practicing under that e-passport.
Yeah, that's my understanding thus far as well, that you have to really be there. And even as a psychologist, you can't be traveling around, even if you're licensed. You have to be physically in your home state.
Yep. Which is different. This is different than the advice we've been giving people for a long time. So SIPAC, it really is a new one for all of us.
Right. So here's the last one, and hopefully you guys can get in. We've touched a little bit on this, but maybe you can get in a couple quick tips here. What are your thoughts about conducting a psychological evaluation outside in order to avoid having to wear masks? Is it okay if you make sure to be in a location where people aren't regularly walking by and you stop talking if someone does approach?
With appropriate informed consent, I think you can do that. But I don't think that you can do it as a permanent solution. This is one of those temporary COVID solutions, which I think makes sense because you're trying to protect the safety of the people that you're with, and you can't really do it remotely. So you have to do it in person, and you don't want to be in a closed office for a long period of time. So that's a good solution, but you have to be very careful about making sure the location is really confidential.
Yeah, I mean, I think about doing,
You don't want to do it out by the swimming pool.
and there are test materials. If you're sitting out there doing block design with someone, first of all, other people walking by, I don't care if you're talking or not, people walk by and be like, hey, what's that? Oh gosh, that's proprietary information I'm not supposed to see because it's a block design. And if you're not wearing masks, that assumes you're 6 feet or more apart, and can you really do an assessment from more than 6 feet away? So I think there's some practical considerations. I have heard of people doing this. I've heard of people setting up tents outside of their home where they have a plastic clear shield in between the 2 tents, and they're in one and the client is in the other. There are certainly opportunities to get creative, but there's a lot of different things to consider as well.
Yeah, don't try to do this in Starbucks.
No. Right. No, and too. First of all, I think this is on some of the FAQs on our sites. I know it's in some of the more deeply answered in some of our other webinars, but also I think one of the really important questions to ask is, do you feel that you can achieve a reliable and valid assessment in that environment? Because I know there are some assessments that you may not be able to. It may be too distracting. It may be who knows what, but we want to think both about the safety issues with COVID, and we want to think about that clinical issue too. Like, can I get a confident assessment if I do it in this way, or this way?